Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to briefly discuss the importance of an independent judiciary under the U.S. Constitution and some of the judiciary's authority under the U.S. Constitution, and how this is relevant to things that are currently happening in the U.S. federal government. In creating our system of divided power in the U.S. Constitution, the founders considered it vital that the judiciary remain truly distinct from both the legislature and the executive. The Federalist Papers, number 79, Alexander Hamilton. The judiciary should have true independence from the political branches of government. FYI, the Federalist Papers are articles about different provisions of the new U.S. Constitution that some of the founders, including Alexander Hamilton, James Madison, and John Jay, published and circulated to citizens of the states to help them understand the new system of government under the U.S. Constitution, which replaced the former Articles of Confederation, which came about 10 years earlier. The U.S. Supreme Court stated in Stern v. Marshall, "There is no liberty if the power of judging be not separated from the legislative and executive powers." The U.S. Supreme Court, citing the former Chief Justice Marshall in Kaiser v. Wilkie in 2019, stated, "Our nation's founders were painfully aware of the dangers of executive and legislative intrusion on judicial decision-making. One of the abuses of royal power that led to the American Revolution was King George's attempt to gain influence over colonial judges. Colonial legislatures, too, had interfered with the court's independence at the behest of private interests and factions. These experiences had taught the founders that there is no liberty if the power of judgment be not separated from the legislative and executive powers. They knew that when political actors are left free not only to adopt and enforce written laws, but also to control the interpretation of those laws, the legal rights of litigants with unpopular or minority causes, or who belong to despised or suspected classes, count for little." James Madison said in Federalist 78, quote, "The complete independence of the courts of justice is peculiarly essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority. Limitations of this kind can be preserved in practice no other way than through the medium of the courts of justice, whose duty it is to declare all acts contrary to the manifest tenor of the Constitution void. Without this, all reservations of particular rights or privileges would amount to nothing. There is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves. It is far more rational to suppose that the courts were designated to be an intermediate body between the people and the legislature, in order, among other things, to keep the latter within the limits assigned to their authority. This also applies to the president and the executive branch." Shifting gears, in viewing some of the powers of the federal judiciary under the U.S. Constitution, Article 3, Section 1 of the U.S. Constitution, which creates the federal judiciary, states, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish." This means that the judicial authority of the federal government is vested in the U.S. Supreme Court and the lower federal courts as they are established by Congress. When the Trump administration makes comments insinuating that federal district court judges and magistrates lack authority to constrain the executive, and that they might only respect rulings from the U.S. Supreme Court, they are wrong. They have to respect and abide by rulings of the entire judiciary. Article 3, Section 2 of the U.S. Constitution states in part, the judicial power shall extend to all cases in law and equity arising under this Constitution and the laws of the United States. The equity powers of the judiciary is a system of legal principles that provides for the courts to remedy legal wrongs that may not be specifically enumerated in the law. For example, some individuals involved in commercial disputes that do not have binding contracts pursue claims in equity for quantum meruit, which allows in some scenarios for a party to recover damages for things like a reasonable sum of money to be paid for services rendered in certain non-payment situations. Article 3, Section 2 of the U.S. Constitution means that the primary judicial power that the federal courts have is to rule on cases arising under law and equity under the U.S. Constitution and federal laws. As you've seen in the Kilmar-Abrego-Garcia case and others, the courts have used their equity authority to attempt to right constitutional wrongs and to protect Fifth Amendment procedural due process. To use the Kilmar-Abrego-Garcia case, for example, on April 4th, 2025, the U.S. District Court for the District of Maryland, through the court's equity authority, ordered the Trump administration to facilitate Mr. Garcia's return to the United States from El Salvador to, quote, restore the status quo and to preserve Abrego Garcia's access to due process in accordance with the Constitution and governing immigration statutes, because, quote, Abrego Garcia was removed to El Salvador in violation of the Immigration and Nationality Act, specifically 8 United States Code, Section 1231, subsection B3A, and without any legal process because, quote, the balance of equities and the public interest weigh in favor of returning him to the United States. On April 10, 2025, the U.S. Supreme Court, in a 9-0 ruling, upheld the U.S. District Court of Maryland's order, stating, quote, the order properly requires the government to facilitate Abrego Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador. Fun fact, as of today, May 23, 2025, the Trump administration has still failed to come into compliance with the U.S. District Court of Maryland's April 4, 2025 order that was affirmed by the entire U.S. Supreme Court on April 10, 2025. The court has the power by congressional statute, specifically 18 United States Code, Section 401, to hold officials in the Trump administration in contempt of court for violation of its order. The statute states in part, a court of the United States shall have power to punish by fine or imprisonment, or both, at its discretion, such contempt of its authority, and none other as disobedience or resistance to its lawful writ, process, order, rule, decree, or command. 28 U.S.C. Section 566, subsection C, provides that the U.S. Marshal Service shall serve as the mechanism of orders of the federal courts. The statute states, quote, except as otherwise provided by law or rule of procedure, the United States Marshal Service shall execute all lawful writs, process, and orders issued under the authority of the United States and shall command all necessary assistance to execute its duties. 28 United States Code Section 566, subsection A, provides that, quote, it is the primary role and mission of the United States Marshal Service to provide for the security and to obey, execute, and enforce all orders of the United States District Courts and Courts of Appeals. Issues involving these authorities are likely to be raised in future proceedings in the 3 cases out of Maryland, Washington, D.C., and Boston federal courts, where contempt of court proceedings are likely to occur in the future against members of the Trump administration. Keep following Executive Coup for further updates on these matters and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. Thank you.